Impact of Influence.
Covering true crime throughout the Southeast.
Hello, friend. In this episode, you will hear an attorney say that the integrity of the system is at stake. What's he talking about? We'll tell you in a few. Matt Harris and Seton Tucker here. So grateful that you're joining us. And how do they join in the conversation, Seton?
You can find us on Facebook at Impact of Influence and also on our YouTube channel.
And the YouTube channel's up and running. Is where you're watching this right now. Hit that subscribe button. It really helps, and support our sponsors, Quince and Mint Mobile. And we're part of the Evergreen Podcast Company. Before we get into our guest, he's going to be talking about what we discussed on the last episode, which was...
Well, we did a deep dive into the state's response to Alex Murdaugh's appeal. And, we had a lot of questions. We thought it would be great to bring on a lawyer who can maybe give us some legal insight.
And that he does. And we're expecting some pushback, but sit back and enjoy. And we're going to break down some of the legalese on this whole response by the state with our guest. Albert Wunsch is joining us. I saw him on Court TV the other night and talking with Vinny Politan. And you do a pod with Vinny, right?
Yeah, well, Vinny and I have actually been working together since 1992.
Oh, wow.
Yeah, so we go way back to the days of Time Warner Cable television. And we were on a news show together, and it was called Bergen County Justice. And so throughout the years, Vinny has always brought me on to Court TV, where I've been with them since he's been there. And then we put together a podcast with him, myself, and a guy named Jonesy, and we all worked at Court TV Radio on Sirius.
I can't wait to check this podcast out because I watched your segment and I found it so informative that I'm putting this on my list of podcasts to check out.
Well, appreciate that. We're gonna be at Crime Con too.
Oh, wow.
Coming up in Denver in the beginning of September. So we're heading out there. They invited us to come out. It's a little different than regular true crime podcast, and that's why we're called Tangent, because we start with the case and then you never know where we're gonna go.
Oh, okay.
So it can be off on anything.
Well, is your background criminal defense or,
I was a prosecutor.
Okay.
I was a prosecutor for 15 years. I was a public defender, and I still work as a public defender in a number of towns, and I do criminal defense work. I also do civil litigation.
So Vinny is famously a prosecutor, so I'm surprised he's even still friends with you.
Yeah, well, Vinny, as I said, Vinny and I have gone back so many years. It's just, it's incredible. What's nice is that, we're all still together and, still working together, having a good time together. And we don't even live in the same state anymore. But the show is based with three Jersey guys, myself, Jonesy, and then Vinny. And so, you get that Jersey slant on things.
Yes. Well, let's get into the Murdaugh deal, the state's response to the defense's appeal. And there's a bunch in there because it was
bazillion long, pages. Very, very, very long.
And what do you think about 182-page
It's
response?
absurd. And I will tell you this, that in New Jersey, that wouldn't be accepted. I mean, to extend it would be, to make it a little bit longer, they might allow another 10, 15 pages, but they're never going to allow something that long.
What would it normally be?
Usually it's 30.
Oh, seriously?
Yeah. I mean, but in Jersey, I can't say what's South Carolina, but I can tell you in New Jersey, reply brief is 30.
Well, it was interesting though, because there were so many issues on this. I know when the defense initially filed their appeal, they just wanted to file it solely on the jury tampering. And the South Carolina Supreme Court said, no, we have to hear everything. So do you think that is possibly a reason why it was so long?
Well, that definitely would make it longer. But I mean, I don't even know why they're even arguing this. I mean, they've got a very difficult position here right now to be able to, be triumphant because, I mean, the Remmer case is right on point. And, any type of jury tampering is prejudicial. Now, it doesn't necessarily mean he's going to get a new trial. Okay. It means that they have to go back now and take a look at this and do a hearing on what was going on, an investigation as to what was going on. And that's what should be done here. The state should want to do it, even from the standpoint of the fact that the system itself, the integrity of the system is at stake here.
Can you explain to our, like, just to backtrack for a second, can you explain to our listeners what a Remmer hearing is and when that occurs?
Well, what happened, there was a case that came out in 1954. It's a United States Supreme Court case. And what it dealt with was the fact that if there was any type of jury tampering, okay, that there was a presumption that there was a problem, okay, and that the defendant could have been prejudiced with regards to what happened. So when you're taking a look at from the standpoint of that, and you had testimony from a juror saying, listen, this woman was telling us, don't be fooled by his body language, don't do this, don't believe him, all that kind of stuff. I mean, that's jury tampering. I mean, if a lawyer did that, we would be in trouble. Okay. And in this situation, because we're not even allowed to speak to jurors. I know New Jersey is a little different than a number of states. If I get into an elevator and there's a juror with me, I can't even say hello. Okay. And the judges will advise the jurors this so that they don't think I'm rude.
I got you.
Because they'll come in, they'll go, oh, hi. And I can't say anything. So I'll nod, but I'm not going to say anything because I'm not allowed to. I'm not even allowed to speak to the jurors after the trial.
Oh, really? I didn't know that part. Yeah.
So if you find out that there is, maybe there's some sort of things like the things that were said, that watches body language or, those type of comments, and you think that they're by a court official, what happens? How logistically, what happens with the Remmer hearing? Like how does that?
They're going to analyze, they're going to do exactly what the judge did when you decided not to give them a new trial. Okay, with asking the jurors questions.
Yeah, that's what I was confused. I thought honestly, the hearing held by Justice Toll was similar to what I envisioned a Remmer hearing being.
Well, but in this situation here, now that the burden would shift to the state to prove that it was a fair trial.
So it's more the burden shifting.
The burden shifting is big on this, yeah.
Right, because so it doesn't mean that if these communications happened, what my understanding is, if these communications happened, that under the South Carolina standard that Toll relied, you would have to prove that that those impacted the outcome of the trial, the jury's verdict. Right. But if the Remmer standard was used, then the burden shifts to the state, and they would have to prove. What would they have to prove?
Well, they would have to prove that it was harmless error. Okay, that this is, okay, it happened, but it's harmless. All right, that there's nothing here that could have changed the verdict anyway. So they're arguing that. If you see, their brief is arguing that he was so overwhelmingly guilty, therefore this is ridiculous. Why are we even talking about this? The evidence was just so, manifestly against him that there was no other way that the juror could have gone. That the jury was going to have to find him guilty regardless. But that's not the way the system works. And that's begging the question. The fact that he's guilty, I mean, that's why we have constitutional amendments. That's why we have different protections. And it's to protect the innocent as well as the guilty and make sure that everything is done properly.
So what you're saying, it doesn't matter that he was found guilty. That has no bearing on whether there was an effect or not, or any of these rules, 504, any of this stuff.
I mean, that the quest for the harmless error, okay, is what the state is going to be trying to do on this, and just saying, regardless, it was harmless, it was no big deal, it wasn't going to change the verdict, it wasn't going to change the case. But the system is, the system needs to have integrity. And if the system loses that integrity, we're doomed. We're doomed as a country.
One thing I was saying was that they can say it had no effect, right? But I bought Frosted Flakes today. It wasn't the advertising or where the box was placed or that stuff. Right? A lot of times we don't know what affects us And that would be kind of my argument if I was making it, right? Just because they say no.
Well, I mean, that's just all. That's the other thing too, is the fact that you've got someone in there who has authority.
Yeah.
Okay, she's a court clerk. She's in there. She's got authority. They see that she almost basically runs the courtroom. Okay, and I mean, I'll tell you that the judges will tell you that I'm lost without my court clerk, and she's the boss, and things along those lines, and they treat them very, very well. And you want to get a judge mad at you, yell at the court clerk, okay, because then he takes it personally and he'll come after you. When I was a judge's law clerk, he brought me in and he introduced me to his secretary, his personal secretary, and the court clerk. And he said to me, "They're going to be here when you're gone." Okay. So remember that in the hierarchy of things, they're more important than you are. And so, that's the way things are treated. So she's got that respect and she's got that authority. And here she is basically putting together a book at the same time. And the book is not going to sell if he's found not guilty. It's not going to sell. The story was finding him guilty, this scion of this great family in South Carolina and the history and this, that, the other thing. I mean, I have the book. Okay. Yeah. And if
I do too.
Yeah. We interviewed her.
Apparently you can sell it on eBay we can make money on this book from what we paid.
Really? We can make, yeah.
Yeah. We interviewed her right when the book came out.
We had her on the podcast.
And we were like, "Are you sure you're allowed to write this?"
Well,
yeah.
There was also an inaccuracy there where she said I was talking to Jim Griffin every night, which was not true. I caught that inaccuracy right away.
Yeah.
Well, so that's the whole situation is that, she's got a motive. She's got a financial motive with regards to this. And I don't know how the state gets around that. I mean, she's in trouble now. They're looking at her with charges and she's looking at perjury. She's looking at a number of different things. So, basically, as far as I'm concerned, if they say this is harmless error, then why are they prosecuting her?
Well, good.
Well, okay. So I want to one of the things that I noticed in the state's brief is they said that these 4 questions, even if you say that the Rummer standard doesn't apply, the South Carolina standard does apply, with the 4 questions that Toll asked the jury,
give those again, which is, was that an accurate statement about your verdict at the time? Was 1. Number 2, was your verdict based entirely on the testimony, evidence, and law presented to you in this case? 3, did you hear Becky Hill, the clerk of court for Politan County, make any comment about this case before the verdict? And the 4th question, was your verdict on March 2nd, 2023, influenced in any way by the communications by the clerk of court, Becky Hill, in this case?
So they're saying what I'm gathering from what the state is arguing is that these four questions that they asked they polled the jurors on prove that the outcome would not have changed if
Rummer or Green.
If Rummer was the standard that they used. Do you have an opinion on that?
Yes, because the thing is that under Bremer, whether it's direct or indirect, if it has any bearing whatsoever, I mean, you're in there making comments. You've got to take the totality of the circumstances. So say this isn't, somebody they saw in an elevator. All right. This is a woman who gets them their lunch. This is the woman who makes sure that if they're going to be sick, that you call her. Okay. If there's going to be a closing in the courthouse, she calls you. Okay. There's a relationship between her and these jurors. So anything that she says is presumptively prejudicial. Anything whatsoever. And it is a real problem for the state.
When you talk about the relationship, there's also, because as part of the evidentiary hearing too, you heard that she was having conversations with some of the jurors about, someone's alimony or some other things that were involved. So she had more than just the
transportation.
Yes.
So she's developing a relationship with them, which is a problem. Okay. But it was also, if you figure it out, there was a motive behind it. The motive was, if she's going to do this book, what better than to get some of the jurors' opinions on things and be able to talk to them and things along those lines. If, she's trying to build a financial windfall.
Yeah, they brought it up in the hearing because they brought another clerk of court who spent some time with Becky and said that she was talking about buying a house.
In the court that she had assisted some, since this was, a very big trial for a pretty small place. And so this neighboring clerk of court had come to assist Becky Hill at times during the hearing.
And Becky had said she was planning, I think, a house in the lake or something like that.
Environment lake house or something along this line.
Oh, yeah. So they brought it up.
We heard some comments, but then there was the argument that, this time frame. So what they're saying is this evidentiary hearing took place almost a year after the verdict was rendered. Right. And that, what Justice Toll was looking at was what was in the minds of the jurors at the time that they rendered this verdict, not a year later when they have had the chance to look at media and, get opinions from other people and that sort of thing.
And that's a fair assessment, okay? Because, time does change things around. And when you start reading the newspapers or you start looking at the shows that are on Netflix and, on HBO and things like that, then you start having these, maybe some doubts along those lines, but it doesn't matter. She was in there pitching for a conviction, and she was making herself known that this is a guy you can't trust. This is a guy that's no good. Look at him. Don't be fooled by this. Yeah. Okay. The system's integrity would be completely erased. No one would be able to get a fair trial. Well, I've had a situation with regards to before I was I have a very interesting prior work history. I was in a punk rock band in the 70s.
Oh, wow. I want to hear about this.
Yeah, there was a pretty seminal punk rock band. There's only 7 bands that played CBGB's, which is the birthplace.
Oh, that's so cool.
More than mine. Okay, so, and we were considered the Ramones' baby brothers. From there, I became a stand-up comedian for 10 years. Okay.
You have a very interesting story.
Yeah, I know. And then the lawyer being the least interesting out of all. So I used to be the host of a TV show that was it was a cable show from a comedy club called Rascals, which was in New Jersey. And I was the MC, and it was a cable show that, basically you had to hook up your TV to your toaster in order to be able to get the show, right? Yeah. And I didn't really think anyone was watching it, but it turned out that there were 3 jurors on the jury panel that I had, put in place that had watched me, okay, and were at the lunch breaks were showing YouTube videos of me with my material.
Were they fans or not fans?
That's the interesting question. Okay. Because the sheriff's officer came out and said, he goes, "Hey dude, you know what? You're very funny." He goes, "But you're really dirty." And I said, how do you know that? And he goes, "They're watching you at the lunch break."
Oh, wow.
On the Rascal show. I ended up getting in trouble because I had not mentioned that when you get introduced to the jury in New Jersey. First of all, we don't do our own voir dire. Okay. We give questions to the judge. We introduce ourselves, we introduce our clients, and then we have to tell them things about our lives so that if there's a potential conflict. I never mentioned that because I always thought that if I did mention that, it would provoke someone to start looking for that.
Oh, yeah.
Yeah.
So I never mentioned it. I ended up getting in trouble because I didn't mention it, and it was declared a mistrial. They dismissed the jury, and then the judge was coming after me for sanctions. They decided not to do that, but I got in trouble for that, and that was basically, I said, "Listen, I didn't do anything wrong. I didn't mention it because I knew, it's like putting the book at the top of the bookshelf. The kids are going to try to get that because they see it up there, so it must be something that they don't want to see. Whereas if you put it at eye level, they don't want to see it." Okay. Right. That's what was going on here. I figured if I didn't mention it, I'd be safe. I didn't mention it, and I got just royally screwed over. But and that was basically after 2.5 weeks of trial. So that's why the judge.
Wow. Oh,
Did
deep
they
step
did,
far
so
in.
did they send it back? You had to do it all over again?
Yeah,
We
Miss
had to go
Crow.
whole trial over again.
Oh wow.
Yeah, it was
Um,
a nightmare. So I mean, like, but the bottom line, it's the sanctity of the jury. Okay, it would have been improper for that jury to continue in that trial. The judge did not want to declare a mistrial because it had already been in 2.5 weeks, but there was no way to unring the bell.
Do you tell
No.
people now?
Yeah. Well, I actually, after that, interestingly enough, I filed a lawsuit against YouTube and a number of other social medias to have all my material pulled off
Ah.
because all of it was copyrighted and they
Okay.
didn't have permission to play it. So everything, with the exception of I think some shows when I was on Uncle Floyd's show.
Oh,
That
now you put
Uncle
the
Floyd, there you go.
now you put the book on the top of the shelf. I'm going to be going home and
you're not going to
I'm
find
going to be
anything. I mean,
searching this.
I was very fortunate to be able to, like, put these letters out, and they withdrew all that material.
So that is the biggest thing, is the jury tampering.
Yeah, but I want to ask
Okay.
this one question about jury tampering. Another argument that the state made in their brief was that Toll was the finder of fact, and she, as a finder of fact, like a jury trial, could determine credibility of
The jurors.
the jurors. And so it seems to me that maybe she did not personally find juror Z credible. What is that a valid argument, or how does that play into it?
The judge was in the position of trying to ascertain, credibility and things along those lines. And the judge has that opinion, or has that right to put that opinion down, but it doesn't necessarily mean it was correct.
Okay.
But does that matter in an appeal? So,
Yeah.
like, does that end it?
It makes it more difficult.
Yeah,
It
because
makes it
she
a little
said,
bit
yeah,
more.
like she says, this is where I put mine. I'm the jury in this case. I find that these other jurors were credible. I maybe didn't find Z credible. So this is how I rule. It does probably make it more difficult.
It does. That appellate courts give deference to judges with regards to their assessment of the witnesses and experts and things along those lines, because you're there, you're watching them. The appellate court only sees a transcript. Supreme Court only sees a transcript. They don't get a chance to sit in the room with the person. So what that judge has to say with regards to their assessment of credibility there's a lot of weight given to that. But I don't think you even get to that point. I think you get to that point because the burden is going to shift, and that's where the court is going to come down.
All
They're
right.
going to come down and say, listen, you might be right. Okay, but right there, it's presumptively prejudicial. Okay, so now state has to prove that it was harmless error or things along those lines.
And the state did kind of try to chip away with the Remmer and the standards that were used, and lots of different case law that was way above my head, basically saying that, maybe this burden shifting still doesn't matter, is just what I took away from it. But again, non-legal.
Well, they have, like, what the was this kid, like, there was I think Smith versus Phillips. There's a couple other cases that came up, but that where they said that you have to kind of show actual bias and this, that, the other thing. I really think that that's begging the question again. I really think that the bottom line is the state of all should be clamoring that we have to make this right. We need to make sure that the rights are protected. And it's not just the rights of the innocent, it's the rights of the guilty.
It has no, like, the bearing of the overwhelming amount of evidence doesn't mean a hill of beans.
That means they need the most protection. Okay. And, it's like the old adage is, like, better that 100 guilty men go free than one innocent man, suffer in jail.
Yeah.
Okay. I'm paraphrasing, but I mean, like, basically the move is, let's make sure the system is correct. The system doesn't just protect the innocent. The system protects the guilty as well as the innocent. And the protections are there for a purpose and for a reason. You can't say, okay, he's really guilty, so we don't have to give him any protections. Who amongst us can say that? And you got to remember also that the defense only has to get one juror, to say, I'm
Well,
not
that's
sure.
the other thing. Like that was confusing to me because it was like they're saying, well, none of these other jurors heard these things or saw these things or were impacted by these things. But, we have the one who was dismissed who says she heard the things, and we also hear the alternate who says that she heard some of these things. But none of the other sitting jurors said that one said they heard some sort of comment, but it wasn't to the extent of Juror Z. So doesn't matter that only one juror heard these things.
Well, first of all, I find it hard to believe that only one juror heard it, and based on what my understanding was, the way she was working through this, meaning Becky was working through this thing. I find it hard to believe that they didn't hear it. Maybe they didn't pay attention to it. Maybe they didn't went in one ear and out the other. Maybe it was like the state saying there was such overwhelming evidence against this guy that whether she said something or not, I wasn't believing him from the get-go. So you don't know. I mean, it's a tough standard. Is it subjective or is it objective? All right. And, but like I said, Bremer's situation is that it's presumptively prejudicial if there is any direct or indirect contact between, that's affecting a juror, or going after a juror, speaking to a juror. I think that they're going to send it back, and I'm not saying he's going to get a new trial, but I mean, he's going to get a little more in-depth opportunity to, see if the system worked correctly.
We'll touch on some of these other things just a little bit. Did you the financial crimes? There was how many? It was a bunch of days, maybe 2 weeks.
No, it was a week. It was a week
A
of financial crime evidence. There were kind of two things. The state is saying that it was important to establish motive, which is, again, I know not required, but it was important to establish motive and kind of connect the dots. And also that the door was opened by the defense
about character,
about questioning about good character on one of the witnesses that they were cross-examining.
Yeah. And so Newman let a lot, a weekend. We didn't think that was going to happen, but do they have any argument on this financial thing?
You mean as to the fact that they used it to try to attack his
character?
Veracity?
Yes.
Right, like the probative versus, what is it? Probative
versus prejudicial.
Prejudicial kind of stuff. Like, how does that, as a lawyer, how does that work?
Well, as long as the door is opened with regards to character, then it's fair game. I mean, the defense made a decision to go the way they were going to go, and you open up these doors. I, as a prosecutor, used to love that, because then I can get, other things that are going on with regards to other bad acts that may have been going on at the time that give you a motive. And you're right. You don't need motive, but jurors love motive.
Yeah.
Well, it doesn't make sense if you see somebody and they're talking about how, he's a great guy. You see we saw a birthday video where he's celebrating with his family, and you see all these things. You're like, well, how could this person who is blowing out birthday candles with his family and, seen on a video goofing around with his son hours before he was murdered, it's hard for just the general population to reconcile how someone could do this. When you see these type of things.
And had they not brought up that in his character, I don't think the state would have been able to bring in the financial information.
Or at least not to the extent, probably, I would imagine.
Of course not to the extent. And to show that, this man did not have integrity. This man was desperate. This man was stealing from Peter to just give to himself. And that, all of a sudden the walls were caving in and he's desperate. Okay, there's a potential lawsuit coming against him with regards to his son. There's this going on. There's that going on. You have all these things that are now forces that are attacking his so-called credibility. And that's all because the defense did what they did. They made a decision to go forward, and I think they were hoping that stuff was not, that the judge was going to keep it out. But, the prosecution's right on that. If they open the door, you can, run a truck through it.
But if they had not opened the door, well,
Probably
also
not.
then it would be a different ballgame. But what about to the extent, can the judge limit it? Like we heard a week's worth of testimony about all these financial crimes. Does a judge have it in his or her discretion to limit and say, okay, we're going to hear from, we'll hear a day of testimony about this, or we'll hear
Well,
just from this witness or something along those lines?
right. The judges have a lot of authority to do that, and they do that all the time. They'll always say, okay, wait a minute. I don't care about the fact that, he was stealing from the lemonade stand when he was 12. Okay.
Yeah.
That's not relevant to what's going on here. We want to keep it between this period and that period. So the judge can limit the amount of testimony that comes in that's basically not dealing with the crime itself, but dealing with attacks on his integrity, attacks on his character after he's been, put up as being, the second coming of a saint. So you're allowed to do that, but the state is usually, handcuffed to a certain extent as to how far back they can go and what they can show and what they can't show.
The Supreme Court is going to rule, and what's interesting, I think, is that Justice Toll worked with these people. She was one of the Supreme Court justices, and they're going to have to rule whether what she did was the right or wrong, I guess. They're also going to have to talk about Judge Newman, who's became a superstar after this and is retired now. So you've got Supreme Court justices.
He labeled America's judge. People loved him because he had such a calm demeanor. He had standing breaks. People just really resonated that he was just
Right.
had just such a calming presence.
So it would seem human nature that the Supreme Court justices, I guess they're technically supposed to remove all that, but it has to come into play at some point, right? Or no?
You know what? They're not going to say that the judge did anything wrong. They're
Right.
just going to say that you need to do this way, not that way.
This
That's
was
what
the
they
right
do.
legal standard to follow. That's
Yeah,
kind of how it's gonna-
that's they'll hit it on that. They'll say that, listen, the judge's assessment on the credibility, is something we take into account. However, the cornerstone of our system of justice is the American jury system, and we cannot allow it to look like it has been somehow perverted or somehow inverted as to what they're supposed to be doing based on the activities of a woman who was integral in facilitating this jury. I mean, that's the other thing too. As I said, it's not, some guy, it's not like the Karen Reed trial where you're seeing the people picketing outside and stuff like that. Okay, that aspect of it is not here. This is someone who is a cog in the wheel of justice.
Yeah.
This is somebody who is supposed to be 100% neutral during this proceeding. The judge is supposed to be neutral.
This might be a silly question, but the Supreme Court, is either going to be new trial or not new trial, right? Or is there something where they say, I need you guys to go back and dig deeper into this?
That's what it's going to do. That's what.
Okay.
That's
It
what
won't be like a new. They'll say you need to.
They're not going to say new
investigate.
trial. I mean, they're
Okay.
going to say, you know what? You need to go back, and the state needs to be able to show that there was no prejudice with regards to what happened.
And so there'll be another hearing about that.
There'll be another hearing on that.
Would that be a Remmer hearing? Would that be a Remmer?
They don't necessarily call that a Remmer hearing, but that would be basically an investigation as to whether or not this person, what the prejudice was there. They're going to go through basically the same steps, but the state now is going to have to be able to say there's nothing here, okay, or that she wasn't credible, or that she's making this up, or things along those lines. And it's going to be a little more intricate than what was done. I mean, I thought the judge did a good job. I just didn't. I was very surprised that the judge ruled the way they did. She did. I mean, to me, once that came up, I really think at that point, the judge has a duty to say the system's been corrupted.
Well, and also she didn't. Was it Juror Z where she seemed to get kind of confused about the question? Remember that? And then she left,
she
and then
waffled a little bit. If you go back and you listen to all the testimony, when Justice Toll was examining Juror Z, it was she said, "Tell me in your words," and she kind of left it open ended. And then when she said telling her in her words, she said, "Well, she said watch the body language and pay attention to his actions and that sort of thing." But in Justice Toll's second examination, when she asked her to open endedly questions, she said, "Well, I think there might have been more questions," but she doesn't actually at that point say, um, she she doesn't say, oh gosh, what
She wasn't clear about.
she wasn't clear. She said watch his body language and watch his actions, but she doesn't say don't be fooled.
Yes.
Like, because don't be fooled is a big difference between
right.
watch his body language and don't be fooled. Don't be fooled means he's trying to fool you.
And her her attorney during the lunch break sent a note to Justice Toll that said she'd like to clarify some of their statements.
They tried to submit
and
an
said, "I don't wanna hear
affidavit.
it."
Yeah, and then they said no.
And quite candidly, look, jurors don't like to get questioned like that. I mean, it's a very nerve-wracking
Oh, she
experience.
seemed really nervous. Like, I mean, she's from probably a small town. I don't know. I don't like public speaking, and to be up there, the courtroom. I was there that day. The courtroom was packed. Their cameras, set up. It was pretty much standing room only. And if you're not somebody who is used to being questioned or in front of people, I would think that it would be very nerve-wracking.
It is. It's extremely nerve-wracking. And it also is a situation where she's getting up there and basically said, my verdict wasn't mine. Like I was prejudiced by this. And, basically you're admitting you did something wrong.
Right. She
Because
also said, I forgot, she said that because she kind of changed it a little bit in the testimony. So she said, I was also kind of bullied by the jurors or whatever.
Yeah. Which both things could be true. I mean, she said that she felt pressure during jury deliberations, which I think is probably just part of normal jury deliberations, but then also that she was influenced by what Hill said. But those two things are not mutually exclusive. She could have felt pressured and influenced by what Hill said.
But also, she had a duty to tell the court that this was happening.
Well, what was really interesting is she was brought onto the stand 2 times during the evidentiary hearing. And the first time that she was on the stand, I think she was the first, but can't entirely remember because it's been a year or two ago. But during this time, it's discovered that some of the other jurors are watching what's happening on their cell phones in the jury room, despite being advised by the judge not to do any of these things. And so when she was being sent back to the jury room, Justice Toll said, "Hey, do you feel comfortable going back to the jury room knowing that they've all just watched what you said?" And she said yes. Yeah. She said, "Yeah, I'm fine to go back."
But it's a nerve-wracking experience to be up there and to be given, to be questioned by the judge and questioned in a courtroom, and especially when, you're not there because you were speeding on Interstate 57. You're
there doing your civic duty. You were performing a civic duty.
Right.
Actually had the dismissed juror, the egg juror, comment on our Facebook page. I had posted an article on our Facebook page about just the pressures and that some of, when someone serves their civic duty being on a trial, not only a lot of times they're going to be subject to seeing like these awful pictures like these particular jurors were of crime scenes and all these things and kind of the impact it had. And she responded, "Yeah, I get it."
Yeah. And now social media, their names are out there eventually. And they take the heat.
No, it's true. And it's, it's a nerve-wracking experience, and it's even more nerve-wracking when you're the defendant, and it's even more nerve-wracking when you know that somebody could be in there who's supposed to be neutral and not supposed to be commenting, making comments.
Yeah.
And that's where this whole thing comes down to. It really comes down to the sanctity of the system. And if we don't promote that, then, we're no different than third world countries where you have to prove your innocence. Okay. We don't have that here. And that's the whole thing. It's not an English system. It's a system where, you have a jury of your peers that comes in and is supposed to disassociate themselves from everything except for the evidence that's presented there. And that evidence is supposed to be clean, clear, and without any type of bias. And with somebody making comments, especially in a trusted position, as much as I hate to see, a guilty person go free, I don't think that's going to happen here regardless. But I do think that he has the right to a fair trial. And he
It's
has
part
the
of the
right.
state's responsibility to make sure trials are fair. That's one of their, right?
That's the whole point of, that's why I don't understand that the state should actually be clamoring to say, we need to make sure this was done right. We need to make sure that his rights were not trampled upon at any stage
It
of
shouldn't
this.
be just about W's and L's, right? It should be more than that. Yeah.
Well, there is. The attorney general's running for governor. There's a lot of other factors that go into this.
Well, there is, but it's never been about W's and L's. It shouldn't be about that. I mean, a prosecutor is supposed to go in and prosecute a case that he knows there is, or she knows that there is something that was done wrong. Okay. We're getting into a situation now where people are just prosecuting cases precisely what you just said, because they're running for office and it's good publicity and this, that, the other thing. That deviates from what the system's supposed to be. We're supposed to be protecting the rights of our citizens.
Well, I have no doubt that if by chance that he is given a new trial, the evidence, they're gonna present this again. It's not like this is going away. He will be prosecuted again. I would assume.
Look, the bottom line is that if I'm the judge, I'd say, listen, if you already said it's such a slam dunk, do it again.
Yeah. Yeah.
I mean, there's a lot of talk about, we get this question all the time, well, what about resources? How much is this costing? Who is paying for this? And I mean, unfortunately, yeah, those are big issues. I mean, I don't know how much this cost to do one time, and it's going to cost the state and our taxpayers more money to do it again, but
it's millions for defense, but not a dime, for tribute. So, and it is defense. It's defense of our rights. Okay, so that's what you have to look at it for. What is it? What are our constitutional rights worth? I think they're worth a fortune. Okay, because a lot of countries don't have it. And that's why we have this situation here. That's why we have these rights. That's why we have this case law. That's why people have attorneys. Okay, and we don't have debtor's prison anymore. We don't have all these different things because people's rights are sacrosanct and they are above everything else.
So, Al, you're going to get to the mail and the things that we do, which is like, you're for Murdaugh.
Yeah, we're going to get some hate mail over this interview.
Yeah, we get it all the time.
Well, what? Believe me,
I don't care. I mean, I think, you just have to,
it's
important stuff to talk about.
The problem is this, okay, you look through history and you look through what's gone on and you've seen innocent people that have been railroaded, okay, and you see people who are sitting in jails for 20, 30, 40 years.
Yeah.
And then all of a sudden, because they didn't get a fair trial or this, that, the other thing, and then somebody says, let's take a look at this, and they get out after that time. I mean, it drives me nuts. And I mean, I not even from the standpoint as a prosecutor, I didn't like seeing cases that were being prosecuted for no reason other than the fact that the cop wrote the ticket. Okay, well, that's not a reason to go forward. If I have a doubt in my mind, I'm not allowed to go forward. And the prosecution has to keep that in the back of their mind at all times. So, I mean, I know I get hit as being a bleeding heart liberal. I was in a punk rock band, so of course I'm going to be a liberal.
I want those pictures.
What was the name of the band? So in case people want to listen.
We were called the Legals.
The Legals, okay.
Oh, were you all attorneys?
The only reason, no. I was 13. Okay.
Oh, what?
Yeah, and my bandmates were 16, and we were playing in bars. Okay, and people would say, "Are you guys, old enough to be here?"
You're legal.
Say, yeah, we're legal. That's how we got the name. But you
grew facial hair early.
I was, 13 playing at CBGB's, and
Crazy.
13, 14, 15, 16. We played there for quite some time. Every Sunday we did 2 shows.
Wow. Al Wunsch is with us. He is an attorney, counselor from Jersey, and works with Vinnie Politan on the
Former punk rock star.
yes, and stand-up comic. The
Stand-up comic.
Tangent True Crime podcast. He's on. It's on social media live every Friday from 12:30 to 2.
Right. And
So
then
there.
every Monday night, 8 to 9, I'm on with Vinny, okay, on Court TV. All right. And it's closing arguments. So
Yeah.
I'm on every Monday night, and we get into this kind of stuff. We talk about all these things, and that I get all the hate mail.
Yeah, of course, right?
It's okay. It's okay.
Tell Vinny we said, hey, appreciate it. I'll really appreciate it.
No problem. See
Thank
all.
you. We appreciate it.
Bye. Thanks, man.
That was really good. I really found it interesting.
Okay, I'm glad. I'm sorry, as I said, that's Jersey liberals. So
No, look, no, we're here for it. I think you're, I think
we're the podcast that's been told we're in the bag for
Murdaugh just for pointing this stuff out. But I mean, I do think that's very important. We try to present all information and let people make up their own minds.
Yep. Well, that's the way to be. And I enjoy the opportunity to be on. Thank you.
Thanks, man. Appreciate
I know I'm going to check out your music.
You're never going to find it. Also, I had to take that off too. I had to take that off. My band is actually still together. They're now a country band.
Oh, wow.
The evolution was after I left because of my mother. After I left, they became pop, and then they converted to country. And so they're down in Memphis now and stuff like that. And they're called Whiskey Falls. So they're playing down there. And then they come back up here every now and then to show off their 27-year-old girlfriends.
Oh, no.
So I just basically try to look for something sharp to get a vein and bleed out. That's what I do. All right. So.
All right. We are anxiously awaiting the pushback. That's his opinion. And when he was on with Vinnie Politan on Court TV, there were 3 attorneys, both defense and prosecutors, and they all kind of felt the same way to a point. But my big takeaway, one of the biggest from that interview, and he's a really interesting guy, is that he said Alex Murdaugh's not going to get a new trial. He doesn't think. But the Supreme Court may say, you guys got to investigate more of Becky Hill's comments and how it may or may not have affected the jury more than just the toll evidentiary hearing we had. Yeah, so I've not heard that theory.
No, that was really interesting. I had not heard that either. Also, just in general, a really interesting guy. Yeah. He was a punk rock guy and a stand-up comedian and a lawyer. I mean, I don't know that you could. That's a trifecta.
It really is. I don't know which the occupations there is less liked. All right, so you can always reach out to us on Impact of Influence Facebook page or Spotify or Apple or our YouTube channel and leave comments like this.
Okay, so our first one comes from Danielle on our Facebook page. She says, all those jurors testified under oath that they came to their verdict based on facts of the case, nothing more than grandstanding for a murderer. I don't know.
The one juror was definitely, I think, possibly... It was unclear that what didn't affect her.
Well, but also, grandstanding for a murderer, that's their job. They're hired to do that. I mean, a lot of people, I get why they don't like defense attorneys. I think people sometimes don't like attorneys in general.
Right.
But, that's the job that they were hired to do, is to see if there was anything wrong with how the trial was conducted. Mm-hmm. And if so, they have to file an appeal.
And I would imagine... ones that aren't pleaded out, that go to trial. I would like to know the percentage of murder convictions that are appealed. It's got to be pretty high, right?
Well, if it's death penalty, it's an automatic appeal.
Right. Exactly.
That's
a good call. This is from Kristen on Spotify, and she's referring to the Jen Wood conversation we had, which was a few episodes ago. That Jen Wood from Fitz News went through all the documents that she was given by an anonymous source. And some of them had some comments or texts that were from Alec to Cousin Eddie and things like that.
Blanca, a few people.
Yes, and the question was, did the defense team get them? And if not, is that another grounds for appeal? We have not heard the defense say anything about that.
No.
So the question was, did they get it and didn't catch it? Or is it not big enough for them to appeal with?
Or maybe they haven't done that yet.
True.
They might still be working on that.
So Kristen says, you know they had it. Dick is just trying to stay relevant. He loves to be in the spotlight and in the news. Who's not been in the news lately, Dick? Alex was found guilty, period. He had a fair trial. He didn't win. And that is why Dick is saying it was not fair. Dick is just being a dick. I know people love to play with his name and whatever, Kristen, but I love your comment. I don't mean to take all your comments. I just kind of think that it's the job, as we said, of a defense attorney to do what they can for their client and do what their client instructs them to do.
But she could be right that they did receive them and they missed them.
And
so we don't know that for sure.
Dick does like the spotlight.
Well, that's true. Who doesn't? Well, not me, but some people.
You don't really like me.
Okay, we also have another comment from our Facebook page from Shelley. She says, people seem to forget no matter how sure we are this man is evil and murdered his family, ethics and conduct matter as justice is pursued. If we allow this with the Alex Murdaugh trial, it must be accepted in everyone's trial. Precedence is reality. Allowing this misconduct to stand undermines every shred of our justice system and what it's supposed to stand for. And there will be no coming back from it. Sorry, but the appeal is warranted.
Well, that's one of the big points you just heard from the interview that he was making was his theory, if we allow people who are part of the court, especially, not just bystanders, to make comments to juries, that sets a bad precedent, he believes. Just to, you kind of got to.
No, he felt very passionate about that for sure.
Yeah.
Now, I will say that the majority of our comments on our Facebook page are like, he's guilty. Why are we wasting our money? All of these things.
Right. And if you are an attorney, legal expert that wants to come on and say, no way in heck, we would talk to you. We'll talk to you for
sure.
All right. Again, we're so grateful that you hang out with us and listen after all these years. It's very appreciated. And we'll talk soon, friend.